disability and disability politics, which we've begun, and we had a very interesting visit by Teresa Carroll that helped sharpen our perspective on certain issues. And then I'm going to move directly into a discussion of disability and disability politics as it affects mental illness, and then we'll look at some other considerations on Wednesday, and the last two sessions of the semester, Monday and Wednesday of next week. We'll pick up any loose ends that we haven't dealt with in that unit, and move on to a sort of a last look at where we are with healthcare reform now, perspectives on the Affordable Care Act, perspectives on efforts during the current administration to repeal or replace the Affordable Care Act, their failure, sideways efforts, and sneak attacks via the tax measures. And we'll take a look at all that. And we'll also have a chance to read President Obama's own words as they were published in the JAMA about the Affordable Care Act, his assessment of it, its accomplishments, its strengths, its weaknesses, and so on. And we'll put that all in the mix for the last couple of days. But let's now pick up the theme of disability and disability politics. And one of the main issues that came up during our conversation with Teresa Carroll was that the Americans with Disabilities Act, the ADA of 1990, though it was a major landmark piece of legislation and a major indicator of our progress as a civilization, as a culture, towards greater acceptance and allowance for people with disabilities to play a role in mainstream American life, it still had many shortcomings. It wasn't a magical cure-all for the problems and the needs of the disabled, especially the physically disabled. Because despite the law, as we heard from Teresa, and despite its very clear stipulations, the landlord in the apartment building where she was living, which was under pressure of law to comply with requests for making the apartments fully accessible, and in spite of the fact that there were special funds available from New York State to actually take care of the renovations that would be needed, that would cover the landlord's costs, still there was a major battle that took many years to resolve before the landlord finally installed a roll-in shower and other specific accommodations for the apartment in which Teresa was living, though it is specified by law that it was needed and essential, and there were funds to pay for it, so the landlord couldn't claim that he had some special undue financial obligation that wouldn't be appropriate. It's also the case, as we heard from Teresa, that the very language of the law really puts the burden on the disabled themselves, those with least power, least financial resources, and gives institutions which are supposed to comply most of the power and authority, and of course the big bucks to hire the fancy law firms to defend their interests. And the language of the law is very clear that an institution doesn't have to retrofit, make itself accommodating to the physically disabled if that would impose, in the language of the law, undue burdens or unnecessary hardships on that institution. All new construction, as in the construction that went into Retna Hall and the construction that allowed that same, that retrofitting of Morey Hall with an elevator for the first time, hadn't been during Teresa's time here. All new construction must conform to the specifications of the Americans with Disabilities Act, but an institution can claim that it would be an unnecessary financial burden, make the disabled prove that they need special accommodations, and that often means that the only way someone like Teresa would be able to represent a case effectively against an institution like the U of R is to join a major class action lawsuit, usually taken by a pro bono law firm or set of lawyers, and involving many institutions in the case that finally got the U of R to make some, put in some ramps and make curb cuts and all the rest of the things, put in the push pads in the tunnels. was a lawsuit that involved several institutions in Western New York, including SUNY Buffalo, and Teresa was able to join that lawsuit. So the burden is on disabled, and that is something that is a major shortcoming and problem with the ADA. But in spite of these, yes?
So the money from the state that make ADA buildings ADA compliant, do those constitute health expenditures, like the public health expenditures that we talked about during the first half of this semester?
I'm not sure where they fit in the budget. I never looked at the New York State budget with that level of detail. It'd be interesting to see. I doubt it, but it's possible. It's possible. I think they are separate funding streams, but it's an interesting question, and I don't know the answer to that. So we have to be realistic about what the ADA accomplished and what it didn't, and we shouldn't lose sight of the real progress that the ADA passed in 1990 represented, especially if we compare it to the way things were before. And in fact, in very sort of gross macro terms, we can get a sense of before and after with regard to the rights of the disabled by looking at two landmark legal actions. One, a Supreme Court decision in 1927, and then use that as a base for looking more closely at some of the details of the ADA passed as legislation by Congress and signed by President H.W. Bush in 1990. So the first instance, the first case that sets a before or the after of the ADA is a 1927 very significant Supreme Court decision that is generally known as Buck v. Bell. You can read its very short decision that is written by not the Chief Justice of the Supreme Court, but a senior Justice of the Supreme Court, Oliver Wendell Holmes, Jr. There was an Oliver Wendell Holmes, Sr., who was a famous physician and professor at Harvard Medical School and a poet in the 19th century. This is his son, and Oliver Wendell Holmes, Jr. was a major jurist, but not a Chief Justice of the Supreme Court, which many people confuse, though his name is attached to this case because he was the primary author of this opinion, and he wrote in very vivid, strong, powerful language that we need to pay attention to. So let's walk through some of the essence of the case and some of the key language, which you can read for yourself on Blackboard because we put this little decision, it's only a few pages, there. It involves a plaintiff, Carrie Buck, as the Buck in the Buck v. Bell, and the Bell of the case is an official in the Virginia state system of government because Virginia had created a colony, as it was called, for the, as you'll see in the actual language of the case, it is the Supreme Court of Appeals of the state of Virginia which affirmed the judgment ordering that the superintendent of the state colony of epileptics and the feeble-minded was right in its decision. So what was the decision? An act that was performed against her will on a young woman called Carrie Buck, who was one of the inmates in this colony, a segregated institution for the epileptic and feeble-minded citizens with limited rights, as we'll see, of Virginia. It is a case that is deeply reflective of its time, and that, as you'll hear in a second as I read some of the language of the case, speaks volumes about the mindset of the 1920s in which this decision was rendered. So Carrie Buck was a feeble-minded, so-called inmate. If you look up Carrie Buck on Google, you'll find out all sorts of fascinating details that come out about what her actual capacity was, what the capacity of her children were, and so on. How she wound up in the Virginia colony of the feeble-minded. And it gets to be an awful story, a very scandalous story, because Carrie Buck was actually raped by someone who's then the seniors of those households had her confined to this institution against her will to shut her up and keep her quiet. And the child was actually the product of a rape. There are all kinds of horrendous details which investigative historians and others have ferreted out. But just listen to the language of the case. This is what the summary of Justice Holmes includes. The Virginia statute providing for the sexual sterilization of inmates of institutions supported by the state who shall be afflicted with hereditary form of insanity or imbecility is within the power of the state under the 14th Amendment. Failure to extend the provision to persons outside the institution named does not render obnoxious the equal protection clause. And so, what happened? Carrie Buck was in this institution. She had a child. It wasn't at least stated at the time, or maybe even known by all the people there, that the child was the product of a rape in a family that tried to hide this case and put her away. She was going to have a child. She was considered feeble-minded. She was a child of a feeble-minded mother in their judgment. And so, to prevent the continued production of feeble-minded offspring, the state sterilized Carrie Buck by cutting her fallopian tubes in a specific sterilization procedure common at the time. She did not give a consent. She objected to the procedure. Someone representing her took the case. State of Virginia said, we have the right to do this. Your voice has no merit, no value. It is not heard. The 14th Amendment, which is supposed to provide equal protection, does not apply to someone like you who is feeble-minded. You have no legal rights. And that was the decision that was then appealed to the Supreme Court, which in this case upheld the decision of the Virginia Appellate Court, which said that the institution had the right, reaffirmed the right. The Supreme Court, in its great wisdom in 1927, reaffirmed the right of the state to do an absolutely involuntary sterilization on this young woman. And here is how Justice Holmes delivered the opinion of the court. And I'm just reading from what you could read on Blackboard. This is a writ of error to review the judgment of the Supreme Court of Appeals, Supreme Court of Appeals of Virginia, affirming the right, etc., to uphold this case. The case comes here upon the contention that the statute authorizing the judgment is void under the 14th Amendment as denying the plaintiff in error due process of law and the equal protection of the laws. So what made it a Supreme Court case is that the 14th Amendment to the US Constitution would prevent the state from involuntarily sterilizing someone because that's not giving her due protection of the laws. And here is the consideration why the 14th Amendment doesn't apply to someone like Carrie Buck. And here is how Justice Holmes explained the details of the case. Carrie Buck is a feeble-minded white woman who is committed to the state colony above mentioned in due form. She is the daughter of a feeble-minded mother in the same institution and the mother of an illegitimate feeble-minded child. The health of the patient and the welfare of society may be promoted in certain cases by the sterilization of mental defectives, under careful regard that the sterilization may be effected in males by vasectomy and in females by a procedure, which are funny spelling and pronunciation, by another procedure, cloning of the fallopian tubes, without serious pain or substantial danger to life. That the Commonwealth is supporting in various institutions many defective persons who, if now discharged, would become a menace, but if incapable of procreating, might be discharged with safety and become self-supporting with benefit to themselves and to society. And experience has shown that heredity plays an important part in the transmission of insanity, imbecility, criminality, etc. I'll comment on this. Now, skipping a little bit ahead into the decision, the judgment finds that the facts have been as recited and that Carrie Buck is the probable potential parent of socially inadequate offspring, likewise afflicted that she may be sexually sterilized without detriment to her general health, and that her welfare and that of society will be promoted by her sterilization, and thereupon it makes the order. In other words, the Supreme Court upholds the decisions made lower down in Virginia, from the institution through the Virginia Court of Appeals. Justice Holmes continues. We have seen more than once that the public welfare may call upon the best citizens for their lives. That is, it could draft young men to serve in the armed forces, as during World War I. That public welfare can call upon the best citizens for their lives if they happen to die in combat. It would be strange if it could not call upon those who already sap the strength of the state, like Harry Buck, for these lesser sacrifices, often not felt to be such by those concerned, in order to prevent our being swamped by incompetence. It is better for all the world if, instead of waiting to execute degenerate offspring for crime or let them starve for their imbecility, which of course is the only possible outcomes of Carrie Buck's pregnancy if she carries it to term, that she will produce degenerate offspring who will be unable to care for themselves, or will commit crimes and do other harms to society. So it would be improper that instead of waiting to execute these degenerate offspring or swamped with incompetence, society can prevent those who are manifestly unfit, like Carrie Buck, from continuing their kind. The principle that sustains compulsory vaccination, which had been decided in an earlier Supreme Court case called Jacobson versus Massachusetts. It's a famous case in public health. The state has the right to force someone who doesn't want to be vaccinated for the good of the public. And we won't get into that, but that's the basis underlying the decision. That's Jacobson v. Massachusetts. So the principle that sustains compulsory vaccination is broad enough to cover the cutting of fallopian tubes. 3 generations of imbeciles is enough. And so ends this Supreme Court case of 1927. You can tell from that, obviously, that it is an angry language of abnormality that drains those better citizens of the state. Differences between those who are disabled and the supposedly able-bodied are described and underscored in demeaning, blunt language. Cripples, imbeciles, degenerates. They have essentially no rights. The 14th Amendment, that's supposed to be a constitutional guarantee of equal protection, does not apply to them, so they cannot hide behind due process and equal protection in order to prevent them from being sterilized against their will. The state has the right to make that decision without any hesitation or any compunction. And the state has the right to take these defective people and to segregate them from the rest of society, to incarcerate them behind walls and barriers and legal devices, because society must protect itself from them and their procreation of equally disabled people if they were allowed to mingle and mix and perhaps take an able-bodied person as a partner in a sexual encounter and produce a disabled offspring. This is clearly the language of exclusion, of nativism, and of very, very rampant eugenics. It is the way the United States, in many of its states, looked at things clearly in the 1920s. And there was a massive wave from state to state to state of sterilization of those who were judged defective, who were kept behind these barriers in these colonies, these segregated institutions. If they were allowed to enter into society, they would be sterilized, and the state had no hesitation about doing that, with the laws and the procedures for sterilization spreading widely across the country. The United States became so famous, in fact, in its sterilization procedures, that a person in Germany who was actually in prison and doing some reading as he was writing a book about his political philosophy came upon the records of the American sterilization procedures and said, now, that's a good example. Other countries should copy what the United States is doing in sterilizing its defective citizens. That German man in prison was Adolf Hitler, and the book he was writing was Mein Kampf, the Bible of the Nazi movement, which praised American sterilization procedures and held them up as a model. And when in power, he applied and extended them in Germany, beginning with the sterilization of mental defectives in psychiatric institutions, and then moving to testing on them a particular procedure of eliminating them via new techniques of injection and gas chamber submission. The genocidal policies of the Nazi regime were tested on mental defectives during the 30s, and Hitler made it clear in his own words that he looked to the United States as a model for how authorities could do that most effectively. This is what perfuses the attitudes, maybe in their most extreme form, but in any way perfuses the attitudes towards those who are disabled in the 1920s, landmark 1927 Buck v. Bell case, and its very explicit, angry language. The ADA of 1990 is a very different legal landmark. It was put together as comprehensive legislation after there were piecemeal ad hoc movements in that direction in the 1970s and 80s. And I believe Teresa, in passing, referred to some of these measures. She cited a particular law by its number. What there were extended civil codes that applied to the rights of the disabled before the 1990 ADA. And these all came as extensions of the basic civil rights laws of the 1960s. So the civil rights laws of the 1960s prevented discrimination on the basis of race, of color, and those new laws were extended to people with other forms of demarcation that separated them from the normal run of folks. And they became very significant in piecemeal ways for those who were beginning to build a case for the civil rights of the disabled. And in fact, the disabled began to organize political actions. Civil disobedience became an important part of the disability movement, based on also the very tried and true techniques of the civil rights movements, as well as using their legislation with lawyers supporting their legal rights. As consolidated and generalized within the ADA, we see a very new moment in American cultural life, a declaration of equality for people with disabilities, an insistence in all the specifics of the ADA that people with disabilities must not be segregated, must not be isolated in separate colonies against their will, but must be mainstreamed in society, and that our policies should be modified to allow people to be mainstreamed by giving them accommodations at work so they can earn a living, giving them accommodations in residential facilities so they can live among us. Actually, that's ironic because the building in which Teresa lives, where I visited many times, is actually a disability colony within the downtown Rochester area. I don't think there's anyone living in that building who doesn't have a disability of one sort or another, physical or mental. But And in any case, the building physically is in Rochester. She can leave the building. She can motor herself to other places downtown. She can go in for a cup of coffee, etc. And that's another part of this ADA, that establishments, restaurants, places that serve people must be accommodating. They must make adjustments as necessary, unless they claim that it will be a great financial burden, just as the university can claim to do that, and then they will have the burden of proof is put back on the disabled person that, in fact, that coffee shop could have made a modification but didn't. The coffee shop will claim that would bankrupt us, so we don't have to, and they'll duke it out in court with usually the establishment winning. But proactively, there's been a wave of pre-accommodation and catch-up accommodation so that people with disabilities can be mainstreamed in social life as well as in economic life and residential life and so on. The language of the ADA is also strikingly different from the harsh, cruel, punitive language of the Buck v. Bell decision. Disability is defined not as something which absolutely marks as inferior and dangerous and worrisome the people with disabilities, but rather is simply an impairment. Disability is defined as a physical or mental impairment that substantially, in the language of the law, limits one or more of the major daily life activities of the disabled individual. In other words, the ADA takes the ADLs, activities of daily living, and uses that as a measure for the limited abilities of disabled people, and instead of condemning them to be consistently and perpetually inferior, says that the people with these disabilities have impairments which prevent them from fulfilling on their own, in some circumstances, the full range of activities of daily living. So it requires that places of work, places of residence, places of social life, coffee shops and the like, movie theaters and so on, must make, in the language of the law, reasonable accommodations. Accommodations. So that in public transportation, employment, public facilities, people with impairments can participate in the life of those institutions, can earn a living, can enjoy a social life, can reside like other people rather than in a segregated facility and be generally mainstream. Here is some of the actual language of the law, which I'm taking from a very good article summarizing the law. It's published in the journal called Law, Medicine, and Healthcare by a scholar named Parmet, Wendy Parmet. Here's her summary. Title I states that, quote, reasonable accommodations to the known physical or mental limitations of an otherwise qualified individual with a disability who is an applicant for as an employee must be made. An employee should be hired if she or he has all the qualifications, and the disability cannot be used as a criterion to prevent hiring that person. Unless that entity, that covered institution, that firm, that hospital, that university, can demonstrate that making the accommodation would produce undue hardships in the operation of the business or that entity. So it defines reasonable accommodations. Some of the specifics you may be aware of, at least indirectly, by knowing some disabled people who are employed in the university and have had special adjustments made. So they may have job restructuring, part-time or modified work schedules, acquisition or modification of equipment or devices, appropriate adjustments and modification, etc., special kinds of phones, desks that would fit people with wheelchairs behind them and have them accessible to computers and so on. These are what institutions must do, and they must also make it possible for people to get in and out and around the institution with appropriate accommodations of the physical structure and space of the institution. That's Title I. Title II places a series of detailed requirements on public transit systems. New and remanufactured vehicles must be readily accessible, and all must be done to make sure that to the maximum extent they are accessible and usable by individuals with disabilities. And that means that the localities must have special buses, special lifts, and special arrangements if those are judged financially too difficult, to make sure that people who need to get around, to move from home to employment and so on, can make those trips. And Title III is about public accommodations, also says that all new construction of public accommodations will have to be readily accessible to the disabled. The statute suggests that all new buildings over 3 stories or more than 3,000 square feet, and all medical office buildings more than 1 story will require an elevator, etc., etc. The problem is not prospective but retrospective. Does an institution have to retrofit? And that's where the battles are played out. So this is the kind of reasonable accommodations that shall be made, and that's why the ADA has been correctly seen as the Civil Rights Act for people with disabilities, and it really extends civil rights principles into this very important domain of our social life. It reflects a new awareness that people in our population may be differently abled. Not that some are abled and some are disabled, which is where things began when you think back to Buck v. Bell. It's not that the disabled must be segregated and they have no rights, but there are people with a range of abilities, and we must make reasonable accommodations to allow them all to participate. So it would seem, on one level, that we have in fact progressed significantly from the 1920s to the 1990s and beyond, as reflected in Buck v. Bell versus the ADA. But how far have we progressed? How truly enlightened have we become? Well, let me rely on that same article by Parmet and just call a certain few things to your attention. The burden of proof, the burden of accommodation is on the disabled. They must show that the institution does not sustain undue hardship by making this accommodation. They can fit it into their budget, their overall business plan. And as I've indicated before, that means they've got to organize legal defense against universities, for example, that have powerful legal teams, are defended by the biggest and strongest law firms in the country, and that will do everything possible to not comply if they can get away with it and are only forced into compliance by certain class action lawsuits. The title also says that the removal of pre-existing barriers, structural in nature, where to do so would be readily achievable, should be done, but the law says also that the removal is not required if it is difficult or expensive in a public accommodation. So again, it's progress, it's advancement, the language is different, the mindset is different, but there also are very substantial blind spots and difficulties. If we have become more enlightened now, how much more enlightened have we become if the disabled, physically disabled, for example, still have to fight so hard in the most enlightened institutions, our universities in some cases, to get the law to apply to their circumstances? Why do those with least means and least power and least money have to bear the burden of that demonstration?
Are the words like difficulty and expensive defined in?
No, of course not.
So
that means it's subjectively up to the lawyers to define what would be difficult. And you can say for a university like the university, well, that would cost you, I don't know, let's say $50,000 to make those accommodations. How many times does the University of Rochester waste $50,000 on its new tricolor brochure advertising its great new programs in this, that, or the other thing? Who is looking at the U of R budget and saying, what are the priorities? The U of R says, we have the right to do that, and will only be embarrassed publicly by a lawsuit that may take on some legs and develop some public reaction to it. It's not quantified, it's subjective, and that means the advantages on the side of the institution with the resources and the legal teams, and it's very rare that someone like Teresa will be able to join a class action lawsuit and have her voice multiplied by being part of that lawsuit. Yes.
Did the class action lawsuit actually reach trial, or did the university decide to settle prior to
I think it's settled prior. That's often the way it goes. The embarrassment, the potential fallout of bad publicity, which is what the universities are so very conscious of or sensitive to, probably was what led to the settlement. So this means that the ADA is clearly progress, but progress of a kind of strange or ambiguous sort. And if we look beyond these markers legally to the struggles that Billy Golfus faced, and by the way, if you don't know yet or haven't tried yet, the film is available. It's not on Blackboard. It's available in the Media Center, somewhere there on G, ground floor of Rush Reese. You could just ask for the film and you'll get it. Has anyone tried it yet? All right. And you got it? Okay, so it's possible. Yeah. Swarms of you should rush to the Media Center. I think there are 3 or 4 copies available. It might make sense for several of you to go and see it together as a group. It's a very instructive and brilliant film. And one of the things that he talks about is how difficult his life is, even though he is supposed to be now very much helped by the ADA. He talks about the struggles to get his benefits. He talks about the struggles to get the ADA applied. And he presents it all with his usual gruff voice and sardonic humor. And so much of the film is about, ironically, helping systems which seem to get in the way of rather than helping people. Clear examples from the movie, which she makes very, very vivid. There is a special form that people with the disability of blindness have to deal with. Blind people are required to fill out a 34-page form for benefit renewal. Huh? That's part of our system. Or there is an encounter in which he's dealing with a social worker explaining that he earned some money by beginning to work again in producing some films, and he was making about $500 a month. That, on top of his Social Security benefit of $522 a month, put him over the legal limit, and so he had to spend down a certain amount to get back under the legal limit, which may have been $800. You put them together, that's $1,022. So that's what spend down means, and he goes around and around and around in a circuit with the social worker. So it becomes very much like that famous routine which you may have seen with Abbott and Costello, who's on first? No, I don't know. No, he's on second, etc. That great routine, by the way, during Thanksgiving, I spent time in Cooperstown with friends and spent a day at the Hall of Fame. That wonderful bit is on a continuous loop played in the Hall of Fame. Abbott and Costello, who's on first? And you can get the full transcript of that if you want to rehearse it and do it yourself. But that's the analogy. That's what talking to the social worker was like for Billy Golfus. And so his comment after going through this and looking puzzled and confused, his comment summarizing all of that beautifully was, quote, "I thought the ADA was supposed to fix all this crap." But apparently it hasn't. There are many other deficiencies in the ADA, and yet it is progress. So maybe we haven't made quite as much progress as we'd like to believe, but we certainly, in dealing with physical disabilities, have certainly made some progress. But what about people with flat-out mental disabilities, with serious psychiatric illness and its consequences, way past the problems of memory or speech or other things that Billy now had to deal with in a slowed down, slow motion fashion after his brain injury? Way beyond that spectrum of relative mental incapacity. We need to get sense of another reality of disabled, the psychiatric disabled or the mental disabled. And I'd like to do that by focusing on another story. We've had stories as our guide. We had Teresa's story presented to us in person, in conversation. We have Billy's story presented to us on film, very beautiful. And in our reading, we have another story of a psychiatrically disabled young man named Andrew Goldstein. And here he is, or was. This is the photo of Andrew Goldstein that appeared in the New York Times Magazine when this story, bedlam on the streets, increasingly the mentally ill have nowhere to go, and that's their problem and ours. It was an article by a very good reporter, Michael Weinrip, that was published in the New York Times, and we have it as one of our readings on Blackboard. Andrew, basic story, was a very bright young man. So bright, in fact, that he was able to pass the competitive exam and was one of those few New Yorkers lucky enough to do well enough to get into one of the special high schools that require competitive exams. He got into Bronx Science. Another high school that requires a competitive exam is my alma mater, Stuyvesant High School. These are very, very special places, and it requires a lot of effort and basic guts and intelligence to make the grade by passing these competitive exams. Andrew Goldstein was one such person, and he did well at Bronx Science. He fit right in. But then he was faced with a sudden, catastrophic onset of major mental illness, of schizophrenia. It's not at all unusual for people at about age 20 to have their first major experience of major mental illness. It's part of psychiatric epidemiology. It is quite common for the first episode of a major, severe to hit someone in the age range 19 to 21 or 22. Mental illness is, in fact, a very serious but seldom discussed public health problem. 1 in 4 adults in the United States suffers from a diagnosable mental disorder. Most are rather mild. We would call them neuroses or behavior oddities or personality traits and so on. Make people a little different, give people some challenges. These are not what I want to focus on now. I'm talking about the 11 million or more people who struggle with severe mental disorders like schizophrenia, in which they really do lose touch with reality and experience hallucinations, illusions that they cannot separate from reality. They don't know what's reality and what's not. It includes major manic depression. We all have mood swings. We all go through situational depression. We feel better sometimes than others and so on. That's the normal run. But we're talking about very severe waves of manic depression in which people really spin out of control during their mania and fall into deep, deep, dark depression during their depressive phases. and can have very little control over either one of those poles. Bipolar disorder, it's sometimes called. Well, there are people with massive endogenous depression. These are serious psychoses, and people with them lose contact with reality, experience delusions or hallucinations, hear voices, etc., have limited or no ability to control their emotions and impulses, and they not only put others at risk. So we hear always in the gun debates, oh, it's the mentally ill that are a problem, not the gun, but the person who holds the gun. Yes, they can cause harm to people, and in Andrew's story, he did cause harm. He pushed someone in front of a train, and she died, which is what made this such an important public issue. But more often than not, the major harm that comes to someone with a severe mental illness is to themselves, and one of the greatest risks that they face, since they don't want to deal with their own condition when they become aware enough of it to face it, and don't want to spend the rest of their lives struggling with it, the major risk is suicide, which in fact is the fourth leading cause of death in the age range 18 to 65. We have a major issue of suicide among people in the armed forces, but suicide is a major, often unrecognized, very powerful public health problem right now. We're running out of time, so let me just tell you where I'm going and why we will be using the handout. You can just take a quick look at it now, but make sure to bring it with you on Wednesday and we'll discuss it more directly. The handout helps us see whether we've in fact made progress in treating mental illness. Maybe comparable to from Buck v. Bell versus the ADA. Have our attitudes as a society towards the mentally ill improved? Is it yes or no? Is it ADA versus Buck v. Bell? Have we made progress, but is there still considerable progress yet to be made? Do we have to travel a far distance to overcome our continuing ambivalence? You can look at side 1 of the handout as maybe before, and flip it over to see what's supposed to be after. So the question we're going to have to ask is after, and after what? Compared to when, before, after, question mark, and we'll pick up our discussion next time. Bring the handout with you.